Hello everyone and welcome to today's Mondac webinar in association with Simmons & Simmons, who will be exploring the issues businesses are facing due to the evolving landscape of tech regulations in the EU and solutions to be considered in the interplay between GDPR, the DSA and the AI Act. My name is Dan Sampaio and I'm joined by a wonderful panel to take us through today's discussion. Alejandro Guerrero is a partner in Simmons & Simmons EU competition law and tech regulation practice based in Brussels and Madrid. He specializes in antitrust and commercial regulation, compliance, investigations and litigation in a variety of sectors, including TMT, energy, consumer products and e-commerce. Specifically, Alejandro advises clients on the interplay between competition law and the GDPR, cybersecurity and other related aspects of EU tech and platform regulations, including the DMA and DSA. Manesh Tanna is a partner in the firm's disputes and investigations team and is also the firm's global AI lead. Manesh's practice focuses on contentious commercial and regulatory issues, principally in the telecoms, media and technology sector. He's represented numerous TMT clients on litigation, arbitration and investigation matters. Jeremy Dornat is a managing associate in the firm's dispute resolution group in Brussels. As the Brussels office's data protection expert, Jeremy advises clients on complex data protection and privacy issues, including but not limited to full audit of processing activities, deploying GDPR compliance program, drafting all types of documents to ensure GDPR compliance and training relevant stakeholders. And completing our panel is Sarah Bailey. Sarah is a French qualified lawyer as well as solicitor of the Superior Courts of England and Wales. She advises on all the aspects involved in the creation, exploitation and protection of trademarks, design rights, copyrights and domain names, dealing with both contentious and non-contentious matters. Sarah also advises on data protection and privacy and has guided clients through their GDPR implementation projects, particularly in the health and financial sectors. Now, before I hand over to the panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane, the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session and throughout the presentation. It's now my pleasure to hand you over to our panel to begin. Thank you.
Many thanks for the introduction, Dan, and it is a pleasure to be introducing this exciting topic to our audience. It is now over 10 years since the GDPR was proposed as a new law by the European Commission, and 5 years since it became applicable. I think we can all agree that the GDPR has fundamentally changed the way in which companies process personal data, particularly companies in the tech sector and companies interacting with or using technology, from a website to the use of devices. The GDPR also started a period of intense legal activity in the EU. In parallel to the GDPR, the privacy regulation was also proposed and is still being discussed at EU level, somewhat stalled for a period of time. We meanwhile also had the NIS2 directive, so the Network Infrastructure Security Directive, and other regulations on personal and non-personal data. At a behavioral level, we also have other regulations that do touch upon personal data issues, such as the AI Act, the DSA, and the DMA. The emergence of all these regulations and rules begs the question, how do they all interact and how the application of one can influence the other for companies that are affected by all this legislation? So if we move on to the next slide, we'll focus on the topic of this webinar, which is the interplay between the GDPR, the AI Act, and the DSA. There are surely issues that are addressed in a unique way by each of these laws alone. However, when reviewed holistically, one can see that there are elements that overlap and interaction between these laws. Subjectively, for example, a number of the topics addressed by the DSA, like dark patterns or online advertising, may use algorithms and AI to elaborate and display content to users whose personal data may also be processed in the meantime. From a governance perspective, these rules also lead to the adoption of all sorts of policies, compliance functions, and appointments of officers who might have partly overlapping responsibilities and tasks. In terms of enforcement, we also in principle have different authorities who might end up deciding on different aspects like personal data protection, AI compliance, and DSA compliance of the same process. So the next question for us is, what can we do about all of this? And this is precisely the topic of this webinar. In the next slides, my colleagues Minesh, Sarah, and Jeremy will touch upon some of these issues and aim to address some of the questions raised by the application of these laws. So moving on to Minesh to explain the interplay between the AI Act and the GDPR.
Thanks, Alejandro, and hi, everyone. I'm going to start with some scene setting, and I'm going to look specifically at the regulatory landscape for AI. Now, we talk about AI regulation, but what do we mean by that? In reality, there isn't very much AI-specific regulation yet in force. A number of jurisdictions have passed some AI regulation. Others are talking a lot about it. We have the draft EU AI Act, which we'll come on to, but actually there isn't that much AI-specific regulation in force at this stage. What we do have is existing regulatory frameworks, the GDPR being the principal one, which we'll discuss shortly, and those frameworks are being used to enforce against AI. The landscape will change, though. In a few years, we will turn to a heavily regulated AI landscape with new AI-specific laws alongside existing regulation which applies to AI. We'll also, as this slide shows, see amendments to existing laws to apply to AI, the best example being an amendment to the European product liability regime, which is likely to be amended to apply to AI, and AI-specific standards. International organizations like the ISO, IEC, and IEEE are starting to publish standards which will apply to AI. Moving on to the next slide, the fact that we're relying on existing regulation has not prevented quite a lot of regulatory and legal action relating to AI, generative AI in particular. And this slide summarizes some of the key legal and regulatory actions that we're seeing across a few jurisdictions. There are class actions, particularly in the US, particularly arising out of IP issues relating to AI. There are also, and this is particularly relevant for this session today, a number of regulatory investigations started by European data protection authorities against AI. No doubt in a few years' time, this slide will become even more congested, although as we start to move to an AI regulated landscape with specific AI regulation, there'll be a significant increase in regulatory action under those specific AI regulations. Moving to the next slide, I think the most important AI regulation on the horizon is the EU AI Act. On this slide are key points that we think you should be aware of relating to the EU AI Act. We'll come on shortly to discuss the interplay with the GDPR. The EU AI Act actually comes from the EU's product safety regime. It's another type of product safety law. The EU sees AI as a product which, like machines, toys, factory components, can cause harm to consumers, and that's what the EU AI Act seeks to prevent. It's a horizontal regulation which will apply directly in EU member states, and it adopts what we call a risk-based approach. More on that in a moment. There are substantive and procedural obligations, and there can be a significant regulatory burden, particularly on providers or developers of AI systems, and particularly those AI systems which are categorized as high risk, which we'll come on to look at in a moment. Now, like the GDPR, the EU AI Act is extraterritorial. It applies in the EU, but it can also apply outside of the EU. If a provider is based in the US or Asia and is providing or licensing AI systems in the EU, they will also be subject to the EU AI Act. So we see this very much as a global regulation. Also, like the GDPR, but perhaps slightly surprisingly with higher fines, there are significant monetary penalties for non-compliance. The latest proposal is for fines of up to 7% of annual global turnover for the most serious infringements. Now, the timing is interesting. We are expecting a final text at the end of this year. There are, as we speak, important discussions going on at a European level. We could, although it's ambitious, have a final agreement this evening on the key remaining points on the Act. Perhaps more likely is that they'll come in the next few weeks. Less optimistically, perhaps it'll be months, early 2024, but hopefully it's either very shortly, potentially as soon as this evening, or in the next few weeks. There's then a 2-year implementation period to allow organizations to implement compliance measures and governance measures to get up to speed with the EU AI Act. It's becoming increasingly clear that that period is needed because it's a complex act. There is lots to do under it, particularly for those in the highest categories of risk. So on that note, moving to the next slide, let's look at those categories of risk. Now, if you take away one slide on the EU AI Act, I suggest it be this one. You can imagine I have this pinned to the notice board in my office at all times. This summarizes the risk-based structure of the EU AI Act. There are certain prohibited AI systems at the top of the pyramid. Now, hopefully not many organizations will be subject to those, but they may be, and it's very important not to be using those forms of AI. Perhaps the two categories which will have the biggest impact and most relevance are the high-risk AI systems and the category below, which I'll come on to in a moment. High-risk AI systems form a large proportion of the Act. They are certain AI systems used as product or safety components of various products set out in Annex 2, for example, AI systems used in medical devices, toys, and machinery. That is to say, AI systems used in other products that are covered by the European Product Safety Framework. And then, more interestingly, perhaps Annex 3, which sets out a discrete list of uses or areas where AI systems will be considered high risk. Some interesting examples are biometric systems, AI used in critical infrastructure, AI used in education, employment, recruitment, for example, and then in other perhaps more public sector contexts, justice, immigration, law enforcement, and democratic contexts. The next system is interesting, general purpose AI systems, foundation models, and generative AI. This is a relatively new introduction to the Act. The Act initially set out with just a use case-based approach to risk allocation, but the EU has realized that these types of AI systems, foundation models, and generative AI are likely to cause issues irrespective of their use. So the EU has had to pivot slightly away from a use-based regime towards a tech-based regime, such that if you are involved with general purpose AI, foundation models, or generative AI, and I should say those provisions are the subject of intense discussion today and potentially further along the road, then you are going to be subject to some obligations around these systems under the Act, so worth keeping an eye on. Then at the bottom of the pyramid, there are lower risk categories, which are still worth bearing in mind because all operators may, for example, be subject to a requirement to use AI in accordance with general principles, but they are relatively lower risk. So that's the background to the EU AI Act. I'll now hand over to my colleagues to discuss the interaction between the AI Act and the GDPR.
Thank you, Minesh. I think that we can go on to the next slides, actually. Hi, everyone, and good evening, good morning, or good afternoon to every attendees. I will now further explain you the relevance and interplay between the AI Act and the GDPR. AI is not really a new technology, but it has clearly gained interest over the past few years and has significantly evolved over the past few years. And as the GDPR is more than 5 years old, we may think that it's already obsolete, but it's actually not obsolete because the GDPR was drafted as technology neutral. It will therefore not have to be updated to include AI systems in its scope of application. You can see on these slides that the GDPR very broadly applies to any processing of personal data. And as you can see, the definition of a processing is extremely broad. Basically, it covers anything that you do with a personal data. It could be analysis, collection, storage, structuring, compiling, and so on. So anything that you do will fall within the scope of processing. Personal data is also very broadly defined by the GDPR because it's any information that will allow you to identify someone. So as soon as you use an information that will identify someone to develop, to learn, or to implement an AI systems, you will fall within the scope of the GDPR and you will have to comply with the principles and obligations of the GDPR. And for example, if you use coded or pseudonymized data, you will fall within the scope of the GDPR. Only anonymous data are excluded from the scope. This can, for example, be the case for aggregated data to a certain extent, but you have to bear in mind that the threshold to obtain truly anonymized data is very high in the EU. And so you have to take that into account when developing a project under the AI Act. Moving to the next slide, you will see that the GDPR and AI Act are both grounded on the same article of the Treaty on the Functioning of European Union, which sets the principle of protection of individuals with regard to the processing of their personal data. So both regulations have a common ground, a common principle of protection of personal data. And the AI Act will not replace the GDPR, it will complement the GDPR. The protection offered by the GDPR currently will be somehow enhanced by the new AI Act and the new AI rules. So the GDPR applies to the development of AI systems using personal data for their design, developments, and implementation. And it will also apply to the processing of personal data impacting an individual. For example, if an AI system allows to make some solely automated decision making, this will fall within the scope of the GDPR, and you will have to take into account the principles and obligations of the GDPR. So each step of AI systems, whether development or implementation of that system, will fall within the scope of the GDPR and will likely require different the compliance with different obligations under the GDPR. You can now go to the next slide. On this slide, you will see the key obligations of the GDPR for AI systems. First, the first key obligation, I would say, is the obligation to determine a clear purpose from the outset and to ensure that that purpose is sufficiently specific and understandable for the data subjects. So you have to wonder why you want to develop and implement an AI system. That's the first thing to do. The next thing to do is to identify a legal ground to justify the processing of personal data that you will carry out within the framework of the AI system. And that legal ground will actually be closely connected to the purpose that you would have identified from the outset. So it's important to identify the purpose, to identify a good, valid ground, legal ground to process the data, and the legal ground will also depend on the categories of data subject that you will use in the framework of your AI system. So for example, if you use very general personal data like contact details, the age, some financial data, you will have certain ground on which you will have to rely to justify the processing of personal data. And for example, if your AI systems imply the use of health related data, for example, that's a special category of personal data, and you will have to rely on other grounds to justify the processing of personal data. Another very important obligation under the GDPR that will have to be complied with in relation to AI systems is the transparency obligations. You will have to inform the data subjects whose personal data will be processed by you regarding different aspects. For example, if AI systems are used for profiling or decision making, automated decision making, you will have to explain to the data subject in an understandable way the logic behind that processing, why you do that, who will have access to those personal data, and so on. Another important principle to be complied with is the minimization principle, which means that you can only process personal data that are really necessary to achieve the purposes you have identified. So as soon as you can achieve your purposes with anonymous data, in principle, you have to rely on anonymous data. If it's not possible and you can rely on coded data, okay, let's move to the coded data. It's only when it's not possible to rely on anonymous, aggregate, or coded data, and that you really need to process personal data, that then you can process personal data. That's a form of cascade that you have to bear in mind. You have also to determine a retention period for the data that you will use to develop AI systems, or that will be created thanks to the AI system. You will have to define a retention period, how long you will store those personal data, and it's a very difficult exercise to implement, but that must be thought as the beginning of the AI projects. You must also make a distinction between the learning and the production phase of the AI project. When you develop AI systems, very often you need data to feed that system. It's a little bit the fuel of the AI system. And very often, the processing of personal data will not be justified in the same way in the learning or the production phase. So in each phase, you will have to comply with the different obligations of the GDPR. You will have also to secure the AI model by, for example, implementing organizational and security measures to be sure that the personal data are protected in accordance with relevant standards of security. And finally, you will have to implement in your AI systems some exercise of rights, some mechanism for the individuals to be able to exercise the rights that they have under the GDPR. Like, for example, the right to access to their data, the right to rectify inaccurate data, the right to erase some data in some specific circumstances, the right to restrict, the right to portability of personal data, and the right to object against processing of personal data. So a lot of things to think when you will develop AI systems. Moving to the next slides. Minesh has mentioned the fact that when the AI Act will be adopted, organizations will have 2 years to implement the rules of the AI Act. And maybe we can take some lessons from the GDPR compliance exercise that the organizations had to put in place also during a framework of 2 years after the adoption of the GDPR in 2016. There are some similarities between the GDPR and the AI Act, and some lessons can be taken from the GDPR compliance exercise. For example, the experience regarding the extraterritorial scope of the GDPR. For example, when you have organizations processing personal data, for example, monitoring the behavior of EU citizens, but for organizations outside of the EU, you must appoint an EU-based representative. That will be the same mechanism under the GDPR, the AI Act. So that's a relevant experience. Controllers and processors must implement data privacy by design and by default. taking the challenges of AI into account and applying the 7 principles of the GDPR throughout the process of developing AI system. So that reflects to take into account data privacy as from the outset of a project about a new technology will probably help also for the implementation of the AI Act. GDPR and AI Act are both regulations that require planning, transparency towards individuals, risk assessments, and documentation. And all those obligations are already covered by the GDPR. So if your organizations have already carried out a proper GDPR compliance framework exercise, you will be able to rely on policies, on some processes internal that have been developed to comply with the new AI Act. Moving to the next slide, please. So we can take some lessons from the GDPR to implement the AI Act, but the other way around, obligations imposed by the AI Act may also help organizations to increase the GDPR compliance. For example, for some high-risk AI systems, some technical documentation will have to be developed by the developers of AI systems. And that technical documentation, for example, could be very useful to carry out a data privacy impact assessment, for example. A DPIA is a difficult exercise. You have to analyze, for example, the implementation of a new technology from a privacy perspective. And that technical documentation could help you to achieve and to meet that requirement of a DPIA. The same applies for the transparency requirements under the GDPR. It's possible to rely on the information that will have to be gathered for high-risk AI systems that could also be useful for GDPR compliance, or also, for example, to complete the records of processing activities, which is required under the GDPR. Organizations must have some kind of overview of all the processing activities that they have, and having such technical documentation, such information collected and developed for the implementation of an AI system may help in that respect. So it was really a very brief overview of the interplay between both regulations, but you will have probably understood that there is a close relationship, connection between both regulations, because both regulations will rely on data to implement and to develop. And so experience of the GDPR can help with the implementation of the AI Act and the other way around. So I will leave now, I think, the floor to Alejandro for the next topic.
Thank you very much, Jeremy. It's all very fascinating on the interplay between the GDPR and the AI Act. So thanks to you and Minesh for that part. So now we move on to the GDPR and the DSA, which, as many of you may know, was adopted last year, partly replacing the e-commerce directive, in order to regulate in more detail the way in which different websites and online actors operate, in particular regarding the hosting and the display of content. When it comes to assessing the interplay between the DSA and the GDPR, we have seen two kinds of levels, depending on the kind of obligation imposed by the DSA. At a first, more superficial level, we see the basic obligations that are set out by the DSA, which might lead to new processes that hosting service providers and online platforms may or will need to interplay to implement or to comply. And perhaps the best example of these new obligations are the ones on notice and action mechanisms, complaint tracking, and out-of-court conflict resolution processes. The implementation of these rules will lead to additional processes of personal data by companies, from complainants, from trust flaggers, or from users in general, that these companies will need to put in place, and also make sure that they're complying with the GDPR in managing all these personal data. This also has an AI angle when one sees that the DSA also enables companies to put in place algorithmic mechanisms in order to decide on complaints, for example, submitted from users, which means that if companies put in place these AI or algorithmic mechanisms to decide on whether a user is right or wrong, even though human intervention might be necessary, there's this additional angle where one might also need to look at the AI Act. But fundamentally for us, this first level, which is more superficial, requires basic GDPR compliance in terms of handling personal data from complainants, for example, or trusted flaggers, and all the obligations that Jeremy alluded to earlier regarding the GDPR. So for example, putting in place security measures, access restrictions, ensuring data subject access rights, and so on and so forth. Beyond this first level, we have the second, deeper level, in which the GDPR and the AI Act interact specifically with other obligations of the DSA, which are the illegal content removal options for online service providers, dark patterns, and online advertising and recommender systems. And as Sarah will explain, these are specific obligations that apply to these exact topics, and the seamless interplay between the GDPR, AI Act, and the DSA might be warranted. So over to you, Sarah.
Thank you very much, Alessandro. If we could have the next slide. Thank you very much. As Alessandro said, we've got some specific substantive applications, if I can get that out, that will have an impact, where GDPR will have an impact. And as we know, I think Jeremy's explained, GDPR, it's the sole text which guarantees the protection of personal data at EU level. So when we're looking at the personal data processing that is involved in these various substantive applications, we're also going to have to be thinking, well, what does the GDPR say about it? So looking at the first point, which is a situation where a provider of intermediary services identifies that there is a risk of illegal content being present, of dissemination of illegal content, and decides to investigate it and to implement measures to avoid that content being disseminated. And there has been a risk up until now, or at least a feeling within intermediary service providers, that there was a risk that by doing that they would lose the benefit of the exemption from liability status. The benefit of the exemption from liability regime that they have enjoyed up until now. And so Article 7 in the DSA is a welcome clarification of the fact that companies are allowed to put in place these measures to detect illegal content without losing the benefit of that regime. So the question is, what is illegal content? Unfortunately, it covers a multitude of sins, images depicting child abuse, non-consensual sharing of private images, online stalking, and the sale of non-compliant or counterfeit products. And these processes will often result in the processing of personal data. There are certain rules that are being examined at the moment, which aim to set out specific requirements, a specific context, a legal context for tracking this sort of illegal use. And for example, it will be the draft proposal in relation to child sexual abuse material. In that proposal, there are requirements for intermediaries to conduct risk assessments and to put in place measures to ensure that these images are prevented from being disseminated. These measures are supposed to be state-of-the-art technology, and they are also supposed to be the least intrusive possible to protect personal data. So there's a clear recognition that personal data will be processed in the context of this type of system. And once this regulation is in place, it's going to provide a lot more legal certainty for hosting service providers. They're likely to be able to rely on legal obligation as opposed to legitimate interest for the legal basis of their processing. But more generally, when we're when carrying out Article 7 type tracking, there are various types of personal data processes that can assist companies to identify and eliminate illegal content. The first is going to be asset-based data processing, where you're looking at the metadata of content, you're applying AI systems to it, you're mixing that with other data so that you can get a clearer picture of what content is being processed, by whom and how. The other types of system are server-based data processing, where you're looking at the number, frequency and patterns of visits to certain websites with a point to identify whether or not there is a participation in the hosting of illegal content. And then finally, client-based data processing, where you're looking at the data on users and their devices, so certain browsing behavior or patterns or connections with others that may give rise to suspicions. And each one of these types of technique will be using personal data. So when you are applying them as an intermediary, it becomes necessary to assess how you are also complying with GDPR. What's your legal basis? Is it going to be legitimate interest or a legal obligation? Have you met your transparency requirements in that you've provided information to recipients of the service that these tools are in place and that their personal data may be processed as a result of them? And then finally, DPIAs, Jeremy's spoken about those already. When we are carrying out these sorts of when we're applying these sorts of tools to identify illegal content, they will often be automated. I think it's generally accepted when you're looking at cases of child abuse material. It's very distressing for individual moderators to have a look at those sorts of images, and therefore you will be heavily relying on profiling and automated decision taking, which means that you need to carry out your DPIA. So moving on to the next slide, we also wanted to talk about the prohibition of dark patterns. That's Article 25 in the DSA. It is an article which prohibits online platforms from designing, organizing or operating interfaces with dark patterns. And so what is a dark pattern? A dark pattern is it's a system that is used to nudge an internet user to take a particular type of action that they would not normally have done without that extra push. And quite often it can have negative consequences for the user. So you can have these dark patterns will be actually sort of woven into the interface design choices. And it means that a visitor to the platform will be presented with choices in a non-neutral way. He may be asked to repeatedly whether or not to make a choice when they've already made a choice in relation to a specific question. It could be making it more difficult to discontinue a purchase on an online platform, or default settings that are very difficult to change. So dark patterns are going to give rise to, can give rise to data protection questions in two contexts. The first is in relation to the interface design and the display options. They may have been built on the basis of the analysis of user data. And in order to do that and to do it in a legitimate manner, companies must ensure that users are informed of the possible use of their data and that it is used for product development or some other similar acceptable purpose. The patterns themselves can rely on data processed from users, so looking at browsing behaviours and interests of people visiting a particular platform. And given the nature of that sort of activity, again, you're going to have to starting to look at various compliance obligations. So GDPR compliance, is the personal data being processed lawfully? Have you met your information obligations? Are the cookie consent requirements complied with? And then again, the AI Act compliance. You have to make sure that the pattern isn't prohibited or a high risk. And Minesh has already spoken to us about those high risk and prohibited types of AI processing and mechanisms. And then finally, DSA compliance. The DSA specifically provides that in relation to dark patterns, they specifically provide that dark patterns that it relates to dark patterns that are not already covered by the GDPR. So it's really trying to take these recommendations, to take these provisions to the next level, to ensure that there is this neutrality in the way information is being provided to users. But that's not to say that Article 25 is there to prevent online platforms from directly interacting with recipients of their services or offering them new services. That's specifically, that is totally permissible. But what is important is that it's going to be necessary to demonstrate at each step that the consumer remains able to make autonomous and informed choices. And if we move on to the last slide, which concerns the advertising and recommender systems, which the DSA also looks at. We've got Articles 26 and 27 of the DSA, which impose obligations in relation to recommender systems and online advertising. That's principally going to be an information obligation, together with the right for users to modify the parameters used to determine the ads that they receive. So in this regard, looking at the question of information, the information requirement is likely to overlap with the transparency obligations in the GDPR. You will see at Article 26, there's an obligation on the platform to ensure that the user can actually identify that what he's seeing is an advert, and to identify who is behind that advert. And that means that by imposing these types of transparency obligations on online platforms, users are actually going to be able to make use of their rights as data subjects. They're going to understand who they can address their questions to, who they can object to, and who they can ask for information about the parameters that are used to determine to whom the ad should be provided. And then the second point to note is just that point, the ability of users to modify the parameters that are used for an ad to be shown to them, or a recommendation to be provided to them on the online platform. And it's by providing visitors to the platform with the right to have information about how these parameters are used. That will obviously, when the user exercises his right, is likely to have an influence on the company's ability to actually, or the platform's ability to actually process that data for online advertising and recommender systems. So any modification to those parameters means that it's going to be very difficult to be processing that individual user's personal data legitimately under the GDPR. So I think the point to bear in mind really in relation to these two articles is that it's not just because you are complying with the provisions of the DSA and the obligations in relation to information and the right to modify parameters that you can ignore the GDPR. The measures concerning online advertising and recommending systems don't amend the existing rules under the GDPR, and you're going to have to, they are there more to complement them, and you'll have to take them into account when you are setting up your online advertising and recommender systems. So that was the last point I wanted to make in relation to the substantive issues, and I will now hand back to Dan, who will be moderating our Q&A session.
Brilliant. Thank you very much, Sarah, and thank you to Minesh, Alejandro, Jeremy and Sarah for your presentation today. Incredibly insightful and very important, I think, as well. So we will be moving on to the Q&A section now. If you have a question, please do send it in. It's a fantastic opportunity to have it answered by our experts today. We've had a sort of two-part question in from David today. I'll start with the first part and then move on to the second once we've had that answered. David asks, working with a B2B market research firm in the US, clients have growing concerns about conducting research in the EU and ensuring we adhere to data privacy laws. We seek to capture perspectives from interviewees on their industry and to specific market topics and questions we have via surveys or in-depth phone conversations. We don't seek our personal or confidential information. Is information such as one's name and email address or basic contact information that may exist on a business card, is that considered personal and hence falls under data privacy laws, and hence consent is required to use this information to communicate with an interviewee?
Yeah, so I will answer that question. First, on the basis of the information provided, it's very difficult to be absolutely sure that the GDPR will really apply. Some further information would be needed to tell that. But assuming that the GDPR applies, I can answer to those two questions. The first question is about what is exactly a personal data under the GDPR. Does that cover also more professional data? And the answer is yes. Actually, the concept of personal data covers really any information relating to an individual that will be able to identify an individual. So if it's in the private life or business, that's the same. So business data will also be considered as personal data under the GDPR. The only exception is the data relating to companies, really data relating to companies, like for example, financial accounts and so on. Those are excluded from the GDPR, but any information that could allow you to identify someone, that's a personal data, and the GDPR will apply from a material scope perspective. And the other question is about the consent. Is it required to use this information to communicate with an interviewee? Not necessarily, because there are different legal grounds to justify processing of personal data. Consent is indeed one of those grounds, but it's not the only ground to process personal data. So you have to bear in mind and to analyze whether there are alternative legal grounds that could be used, because it's true that the consent is a very strict legal ground under the GDPR. There is always the possibility of a person to withdraw a consent that has been given. So if you can rely on another legal ground, it would be preferable to do so. And maybe one last comment about the fact that you are in the US. If there is a transfer of personal data, you should also bear in mind that transferring personal data collected from the EU to the US may also have to comply with some specific mechanism to ensure an appropriate transfer of personal data to the US. For example, there are some standard contractual clauses drafted by the European Commission that can be used and concluded between the exporter of data and importer of data in the US. And there are also other mechanisms like data privacy framework, which is a new scheme that has been agreed between the US and the EU. So different things that should be taken into account, but assuming that the GDPR apply, there are indeed things to comply with.
Brilliant, thank you, Jeremy. I think that was an incredibly detailed answer, so thank you. David did follow up with this question, just to add to the prior question. If one is at a trade show and starts a conversation with someone in the EU, such as a key opinion leader or SME, and the dialogue turns into an interview to get their perspective on market issues, do you still need to get some kind of consent from them? Doesn't seem practical to apply this element of GDPR if the person's name, title, and where they work, for example, is considered personal data, and we welcome your take on this. Thank you.
Again, the consent is not necessarily the only legal ground that you could rely on, probably, particularly in the context of an interview. But we could also maybe consider the fact that they spontaneously provide you with the information as a consent that you process the personal data. Particularly if that person understands that you will keep that information. But the tricky thing, I think, is not necessarily the legal ground to process the personal data. But even if you have a legal ground to process the personal data, you have to inform the person accordingly, meaning the purposes for which you will process his or her personal data. And that's the reason why there are a lot of information notices that are provided to data subjects. It's to inform them on how their personal data will be processed. And I think that here, if the processing of personal data starts with a discussion between parties, it will probably be important as soon as possible to provide that person, maybe via a follow-up email with some kind of privacy notice to explain how your organization will process his personal data.
Brilliant. Thank you very much, Jeremy. And just to reiterate, if you do have a question, please do send us in. We'll have time to answer it. We had a few questions that came in before the webinar, and you may have covered these, but I think it would be good to get perhaps a perspective specifically on these questions, and just to reiterate your answers to those. So how does freedom to conduct a business, Article 16 of the EU Charter, apply in the face of GDPR's right of privacy?
Maybe I can take this one, Dan. And this is a question that has been raised by many clients in the last years regarding not only the GDPR, but also other new emerging regulations like the DMA, DSA, etc. And I think that the answer is quite simple, right? I mean, one, there's the freedom to conduct business and the freedom of economies is enshrined in the EU, in the Treaty and the Charter of Fundamental Rights. So there's no doubt about that. But of course, all economic activity has to be conducted within a certain legal framework that is adopted in order to protect other rights, such as, for example, fundamental rights or the precise freedom of economy and to conduct a business, for example, regarding the adoption of competition laws, the DMA. With regard to the DSA, we also have the protection of other rights and interests, such as intellectual property, with which Sarah is very familiar. So all these rights come into play when enacting this legislation that aims to limit or to establish the boundaries of the freedom to conduct a business. And of course, the mere purpose of conducting a business does not give companies the right to violate personal data protection rights or to violate intellectual property and so on and so forth. So I think that explains the adoption of this new legislation that aims to transpose to the virtual and online world what is already commonplace in the physical world. And this is the way in which these laws interact and will interact going forward.
Brilliant, thank you, Alejandro. Is it possible to conclude a breach of GDPR in relation with the information of an entity, maybe not specifically a person?
Jeremy, do you want to go ahead regarding the GDPR angle?
I'm sorry, I think I didn't get the question.
Is it possible to conclude a breach of GDPR in relation with information of an entity, perhaps not of a person?
If the information is really information about an entity, a company, and not an individual, it will not fall within the scope of the GDPR. But sometimes it's difficult to draw a line between information of a company and information about an individual. But if it's only related to a company, it will not be a breach because it's not within the GDPR. Maybe it could be a breach of some other regulations, like for example the protection of trade secrets. I don't know, but as such, probably not under the GDPR.
Excellent, thank you. Is the application of privacy laws transitive? For example, if my AI system gathers data from your AI system, do I have to provide the same data subject rights to the original subjects that you learned from?
Yeah, interesting question. I think it really depends on your status as a controller or processor vis-a-vis those original data subjects. So I think you'd effectively have to do the same analysis under the GDPR as if they were your own subjects, if that makes sense. So I don't think there's any magic in that just because the AI system's involved. I think you've just got to do the same assessment. And it sounds to me that you may not necessarily be a controller or processor, but you'd have to look at exactly how you're using the original subject's personal data.
Brilliant, thank you, Minesh. And as always, with any of these questions that are sent in, we do encourage you to get in touch with our speakers today if you'd like to speak on any topics or themes in any further detail. Jeremy, just going back to your explanation of GDPR's application to work emails and work-related personal data of employees, and we have an audience member who's asked a question if that indicates that in the event of a data breach, the entity responsible would be obligated under Article 34 of GDPR to inform the individuals whose data has been compromised or the respective companies where these individuals are employed about the breach.
Actually, we have to check if the conditions for the notification to the authority or to the individuals are met in a specific case. So sometimes it happens that there is a data breach in the meaning of the definition of the GDPR of a breach, like a theft of a laptop, for example, an email sent to a wrong person, etc. But in order to identify whether a notification is required to the data protection authority, local data protection authority, or the individual concerned, one must assess to which extent there could be some risks for the rights and freedom of that person. Meaning that, for example, if a laptop is stolen but is extremely well protected, and that actually the personal data are sufficiently encrypted to prevent any unlawful use, in that case, maybe that the notification to the individual will not be necessary. But it's always it must always be assessed on a case-by-case basis, and it must always it implies always an analysis from an IT perspective to understand really the risks for the persons concerned by the breach.
Brilliant, thank you, thank you very much, Jeremy. And looking at the time, I think we will need to conclude our Q&A section there, but thank you very much for all of those questions that were sent in. And we'll move on to our closing comments. I think perhaps just looking at the time, perhaps Alejandro, if I can hand to you for just any key takeaways that you would like our audience to leave today's session with.
Sure, thanks again, Dan. These are changing times, I think, from a new regulatory perspective. We have the new AI Act that, as Minesh explained, will be adopted soon. We have the very recently adopted DSA that companies are still getting familiar with. And even the GDPR, which companies invested a lot in complying with around 2018. And since then, companies have been slowly been subject to enforcement activity and still needs to be looked at and not to fall under a blind spot. But all these new rules and others to come are going to affect the way in which companies structure their compliance functions, adopt their policies, and shape the way in which they act on the market going forward. So it's important to address all of these aspects of the application of this new regulation from a fundamental perspective in order to ensure that companies will not be hindered internally by their own bad choices from the beginning, and make sure they act on the market appropriately and they're compliant with the laws and obtain the best results also economically for the operation of the business. So we're advising many companies from this perspective, and we would be happy to respond any questions attendants might have in the future after this webinar. Thanks so much again, Dan, for giving us this opportunity to explain this very interesting topic to this audience.
Thank you very much, Alejandro, and thank you, Manesh, Sarah and Jeremy, for your insights and your time. It's been a pleasure to spend the afternoon with you. Thank you very much to our audience for being with us too. I hope we can see you again soon. But for now, goodbye.